Guys, I really, I am so sorry. Eh? Hey, I'm sorry. We are starting late. It's because number one, your colleagues were. Hey, hi. Mtwa,
Hi.
hi, how are you? I don't know whether someone has unmuted and they're trying to say something, but I can't hear them.
Yeah,
Um,
you were saying you bring back the camera. It was enlightening the session.
Rudisha camera, Lydia.
mbona mnataka kuniona? Si mnataka content ama?
Zote.
Any,
So
um,
what is zote?
well, I think you guys see. Well, I don't want you to know me when you meet me, yeah. But anyway, yeah, I could have it on for a few minutes and then I put it off because I can't have my camera on. And at the same time project. Yeah, it's not possible to do that. I have to do one thing at a time. So let's wait for your colleagues to join. We get quorum and then we start. We have had a class for LWD, but that was a while back. So what I will do, I'll try to I'll just start from scratch. This particular unit, it's a very petty unit. You know, those units where you think you feel like but usually for LWD it's extremely petty. You have to punctuate, you have to remember to have good syntax because the way you know your sentence structure, your paragraphs, that is extremely important for LWD. Now, for this particular paper, I ignored LWD. I never took LWD seriously. Maybe even most of you, that's what you might be doing right now. You're like, no, let me just focus on the forces. However, LWD it's a very petty unit. You have to keep on drafting, just like civil and criminal and other units that you're drafting. You have to keep drafting for LWD because it's majorly drafting, yeah. When I was revising for LWD, there's a particular material which I have for LWD, which we will use. And then I'll give you a list of what you're supposed to draft in LWD. Guys drafted a power of attorney last year, and this year they did a demand letter question 1. So I'll give you a list and then we see what might be tested in your paper. Of course, it won't be a power of attorney, neither will it be a demand letter. So let me give you that list. And then I project the slides. Okay, I project the slides. So just you can write that list because that is what you will use. Number 1, demand letter, and then I'll share the course outline as well before we start. So demand letter, that's one of the documents which you might draft in LWD. And then number 2, reply to demand letter. Actually, that question for March 2023 this year, guys were supposed to draft a demand letter and a reply to demand letter. And then number 3, a legal opinion. So write a legal opinion. And then number 4, so you've written demand letter, reply to demand letter. Number 3, legal opinion. Number 4, agreements or contracts for service, basically employment. Majorly for LWD, they're either employment or supply of goods. Yeah. So there is that contract of service. And then the other one, number 5, power of attorney. But as I was telling you, October, that receipt paper, it was power of attorney. So highly unlikely you guys will have a power of attorney, but just write power of attorney, number 5. A power of attorney can be specific or general. So you have to remember as you're practicing that your power of attorney could either be specific or general. And then you have a deed poll. And then we have deed poll is number 6. Deed poll was April 2022. I'm not sure that could be option 1. Deed poll it has standard form. Yeah. So that's number 6. And then the other document is an affidavit. And then the other document is a statutory declaration. And then the other document is a bill. I think you should be drafting bills right now because this is your data. And then the other document is amendment of bill because there is an amendment bill, and then there is an actual bill. Yeah. And then there is a case brief. You guys might draft a case brief. And then there is a policy, but they just try and keep up, just make a list of all those, because you majorly LWD, you just draft. Yeah, you're going to draft a lot. So policy, and then legislative instructions, and then regulations. I think that's a list of like 15 things. Yeah. So let me share my slides. You guys you'll see me in the corridors of justice. In the meantime, I'll have to project the slides. I'm not able to do both at the same time, unless I learn how, but not today. So let me just share my screen. Just give me a very quick minute, 1 minute, and then we start. In the meantime, check your course outline. Okay, I can project mine before we start. We discuss it a little, and then we start drafting. Okay, guys. So sorry, let me share the course outline. It is by drafting. And by the way, more often than not, especially out here, yeah, you know, you meet someone, maybe they're a pupil, or maybe they're in their holding over, but the basic, like a basic structure, like just structuring a sentence is a problem. Yeah. So don't take LWD lightly. It's actually a very important unit. It actually goes over and beyond your KSL and your practice, because usually as an advocate, what I learned is that cases are usually won in chambers. And basically that means how you write is super important. And of course, how you write, you pick good writing and effective writing skills from your LWD. So it's not just a unit, by the way. And if you're a good drafter, you become indisposable, because right now, as you know, guys are being admitted every month. Yeah. Yeah. So judiciary is admitting guys to the bar like on a monthly basis. This year, I think guys have been admitted 3 times so far, and there is another admission. Yeah. So how to make sure that you actually stand out is by writing very well. You can be an extremely good orator, but you have a challenge in writing. You'll be half baked if you're an advocate who can. You're extremely. I know such a very good orator, but they can't do a basic letter. Like they can't do a letter. Like it's a problem doing not even a pleading, a letter, yeah, to a client. So writing is actually important even in your, it's actually, you stand out if you can write well after your pupillage, when guys are being told, by the way, over here, you're yeah, we are done, you're done with your pupillage, you just we wish you all the best in your career endeavors. Guys will want to retain you because you can write. Writing is super super important, so just don't take it as a unit, yeah, just take it as something which you'll need way beyond your KSL after you're done with your KSL and at your pupillage, because you'll automatically stand out if you can write well. So legal writing, the first topic usually is introduction to legal writing. It has qualities of good writing, qualities of good legal writing, plain English and legalese, gender neutral language, which we'll discuss shortly. So my intent is to discuss this, the intro, briefly, and then very quickly we start drafting, because question one is usually drafting. Yeah, so you're going to draft among that list that you've written. One of those documents will be your question one. Okay, so let me just, I don't want to digress today because I want to cover as much base as possible. So let me project the slides, and the slides I'm going to project are not slides per se, notes. This is what I actually used, by the way. For me personally, I didn't have any other document like this. This is everything I used. I plus a book called Brian Garner. I'm not sure whether you guys have interacted with Brian Garner's book. It's a book on plain English. I'll share Brian Garner's book. Just a minute. I want to share the slides again because I think I had opened them from the email. Anyway, as long as you guys can see, but it looks too tiny. Let's see what to do. So we are going to start from topic one. You could have your course outline. Okay, here we are. All right, here we are. So we are going to start with intro to legal writing, but I won't belabor the point a lot. I just want us to start drafting, but you have to lay bases. So usually, for you to know what goes into your piece of writing or whatever you're writing, you have to remember qualities of good writing. And of course, you've already said that words are dominant tool of trade for lawyers. How you write is super, super important because, as I've told you, my pupil master kept repeating that cases are usually won in chambers. Even before you open your mouth to address the court verbally, the judge or the magistrate should have already been convinced by whatever you wrote. So good choice of words and good piecing together of the words is equivalent to effective communication. So your syntax, or the words that you choose to use and how you piece them together, how you weave them together, ultimately makes your communication effective. Okay, so as you're writing, for you to be able to communicate effectively, you can communicate because you're explaining something to a client, of course, maybe in a legal opinion, or this particular client they came to your chambers, they ask you to write something for them, or they ask you to, mostly legal opinions, or your pupil master or whoever the managing partner asks you for a memo. So how you communicate effectively is through your good writing, otherwise people won't understand you. Let's start with qualities of good writing. Number one, making choices. Making choices basically means whatever goes into your let's say letter should be there because you intended it to be there. Nothing should be there accidentally. Let's say you use some strange word because you had your colleagues use it and you have no idea what it means, or you just put a word and it doesn't make any sense, like it's not, the sentence is not, I'll give you examples later, but if you clarity basically is number one, you're going to use make sure you don't use passive voice, because passive voice, you'll lose clarity if you're using passive voice. So you're going to, one of the ways of achieving, because the examiner will ask you how do you achieve clarity, then you will say by using active voice, doing away with ambiguous words, using simple ordinary language. That's how you achieve clarity. So clarity is the hallmark of good legal writing. Number three, logical structure. Logical structure basically means you know, sometimes you start from A, B, C. Don't start with A and then you go to Z and then you go to F. Yeah. So your piece of writing should have some logical structure. It's flowing. Okay. So basically, you make points as they, for example, if let's say you're doing a letter, you'll ideally start with an intro and then your body, maybe discussions as you've had with your client, and then you conclude. Yeah. And then spelling mistakes. I think your God, personally, I make a lot of spelling mistakes, especially if I'm writing with a pen. So spelling, you have to make sure you don't have any spelling mistakes or spelling errors. Ideally, you look very unprofessional. Yeah, if you have spelling errors, take all reasonable steps to eliminate spelling mistakes. Of course, sincerely, what you can do is make sure you're spelled correctly. You know, you're not typing with a computer, so there is no one to indicate that there is an error. It's you and you alone. So you have to make sure that whatever you have to proofread your work and make sure that everything is spelled correctly. And then grammar is avoid grammatical errors, punctuating, don't have misplaced commas, misplaced full stops, incomplete sentences. So avoid grammatical errors, and the way how to avoid grammatical errors is by proofreading your work. And then punctuation basically means commas, full stops, semicolons, whatever you guys are told to class 4 for English aid. Yeah. So make sure your work is properly punctuated. And then precision means don't beat around the bush, especially, you know, right now people got tired of reading lengthy legal documents. You want to sound clever, so you say you circle before you go to the point. Yeah. So be precise, say exactly what you want to say. Don't waste, don't be vague, don't be general. Advocates are very, very, actually, like, I think it's just it's the culture, very vague, extremely general. But remember, as you're writing, you have to be extremely precise. Don't be general. Non-ambiguity, be clear as they come. Use words which have simple meaning. You know, if, for example, you use a word landlord, make sure landlord in your letter means landlord. We don't have any two landlords. They can be confused. So don't be ambiguous, be extremely specific if you're referring to people, to places, or to anything. And then conciseness goes hand in hand with clarity. So concise basically means being succinct and straight to the point, avoiding repetitions, unnecessary repetitions, long digressions. So you just say exactly what you want to say. And then completeness, a good sentence or good communication in writing should be complete. So as you're being concise, avoid the danger of being incomplete, because you can be too concise, like you're extremely concise, and then now you are incomplete. You're concise now, no one understands what you're saying. So you have to balance the art of being concise, and at the same time you're being complete. So everyone who reads your work will understand exactly what you're saying, because it's complete, at the same time it's concise. And then elegance, Kiage J is the epitome of elegance in regards to writing. Yeah. I think you polish it over time. So your piece of writing should be elegant, which means, you know, someone is reading it and then they want to keep on reading. Yeah, because it doesn't have clumsy phrases, it has flow and some rhythm, you know. Like it's almost poetry. Yeah. And then shorter sentences, make sure you're using short sentences. Don't use very long sentences, because of course that means you're not being concise, and you might lose your reader, and you might be very general if your sentences are very lengthy. So usually what you do, you can have your average sentence length below 25 words. So you could just just make sure as you're writing your sentence, is endeavor to have your sentence don't have more than 25 words in one sentence, because it means that sentence will be overly long. Okay. However, as you're writing your exam paper, don't start counting words. Yeah. But of course, as you're reading it in your mind, because as you're writing, you're seeing what you're writing. if you see this sentence is becoming overly long, then what you do, just break the sentence and then continue your next thought in the next sentence. Don't have very lengthy sentences because you strain the memory of the reader. The reader gets tired. You might actually lose the meaning or whatever you intended to communicate. So remember, qualities of good writing: you make good choices. Whatever is there should be there because you wanted it to be there. Be extremely clear. And then your logical structure, everything should flow. And then spelling, avoid spelling errors. Grammar, avoid grammatical errors. Your adverbs, use the correct tense, correct adverbs, correct verbs. And then punctuation, punctuate your work. Just proofread it before you submit the paper. See whether you've punctuated, because the person will be marking that paper. If you don't have a full stop, and ordinarily it should have been there, they'll be offended. Yeah. And then remember to be very precise. At the same time as you're being precise, it enables your work to be concise, however, be complete while you're at it. Elegance, your work should be elegant, which means it has some flow, it has some rhythm. However, elegant writing comes with a lot of practice. And use short sentences. Endeavor to keep your average sentence length below 25 words. Okay. Plain English, I think you've been told a million times what plain English is. Yeah. So plain English is English that is clear and well written. Yeah. It is basically English which has all these elements. Plain English is the English which has achieved all the qualities of good writing. So plain English avoids any legal jargon. It actually avoids any those Latin terms, and uses extremely clear and simple words. So plain English can be defined as use of straightforward language which conveys meaning clearly and simply. Ordinarily, the language of the law is very complex. I think, guys, at KSL, you because it's extremely complex. It is replete with technical terms and convolutions. And therefore, people ordinarily will actually won't understand what you're saying. So if you're addressing your client in a legal opinion and then you start telling them volentin and fit injuria, you're telling them quit solos edit, they will not understand what you're saying. So use plain English, which basically means you're using very clear, simple words which are easily understandable by your client. The problem with legal language is, number one, many legal documents are lengthy, overly written, self-conscious, and repetitive. I think this goes without saying. Even like simple submissions, you guys, you're just doing, let's say, an application for setting aside a default judgment. And then someone does submission 20 pages and they are repeating things. They are quoting like an entire case verbatim, like half of that submissions, they're quoting things verbatim. So usually many legal documents are lengthy or overwritten and very repetitive. Number two, they consist lengthy sentences that lengthy sentences and involved sentence construction. We've said you have to avoid lengthy sentences, otherwise you strain your reader. But most of the legal documents, including judgments, some of them, they use lengthy sentences. You don't even have pauses. Yeah. Number three, they are poorly structured and designed. The paragraphing is poor, the sentencing is poor, the syntax is bad. So most of the legal documents or legal language has a problem with poor structure, and then they suffer from elaborate and often unnecessary cross-referencing. You've read a document, and then in the document, in the body, within the body of the document, it has supra, ibid, such. So it suffers, legal language suffers unnecessary cross-referencing. They retain archaic phrases up to this date. Archaic phrases are used on a daily. Like if you're in a law firm or you're working as an advocate, you meet other advocates, or you're in a setting where there are advocates. Someone will just throw in some archaic phrase. You have to Google, and then they use supposedly technical terms, of course, foreign words and phrases, especially Latin maxims, and then they are unintelligible. This language is unintelligible to ordinary reader. You don't sound clever, yeah, to Anjiko. Anjiko does not understand exactly what you're saying. So there is this particular question. It was August 2013. The question was, is there a contemporary problem with language of the law? And if in the affirmative, justify your answer with reasons and practical examples. So ideally, if of course, this is how the questions are usually tested for plain English. So these are your answers, but you have to remember examples, because the assumption is if you don't have examples, then there is no challenge with the legal language. What is being done to promote plain English? I'll share with you an article on that. Guys, please allow me to share demand letter. I just want us to draft, because these are things you can read, yeah? But I want us to majorly draft today, okay? So I am going to scroll down to, there are other things here on this slide, characteristics of plain English, but things we've already mentioned, how to spot the English is bad, yeah? So let me just scroll down to demand letter. You guys will read the theoretical bit, and then we could focus on drafting because of time. Let me just scroll down, and also make sure you look at transitions as well. It has been tested time and again. Scrolling down to also look at active and passive voice. I'll share, these are really good notes, but let's just draft, okay? So usually drafting is second semester. The first semester, guys are taught about effective sentences, effective paragraphs. You look at psychology of writing, which includes revising, editing, proofreading. And then your second semester, when now you have the skill, yeah, you understand exactly how to write, then you start writing during your second semester. So that is what I want us to focus on, and we'll start with drafting letters. You wrote a letter. Okay, demand letter is a form of a letter. So we are going to start with a demand letter. We won't look at a letter, because if we discuss demand letter, basically you've done letters, okay? So demand letters here, it's page 35. A demand letter is a letter sent to the defendant on the basis of the client's instructions. You don't wake up and you want to send a demand letter. So you only send a demand letter upon being instructed to send a demand letter by your client. And a demand letter is the primary purpose is to set out the basis of your client's claim and inform the addressee or the recipient that your client will sue unless the addressee does what the client demands. So basically, a demand letter, in a demand letter, you're just telling this dude, number one, you're supposed, my client demands that you do this and this, and if you don't do this and this, then this is what you are going to do. The structure of the demand letter is the same as general letters. Let's look at what goes into a demand letter. Your first paragraph in your demand letter, which we're going to look at shortly, is an introductory paragraph. And this paragraph usually establishes your mandate as your client advocate and should clarify that the letter is being written on your client instructions. So your first paragraph, you just say the above matter refers, and then you say we have been retained, or I have been retained to act or to by the XYZ to address you as follows. Don't say Azia Randa, okay? But we'll look at that. So the first paragraph is the introductory paragraph. The second paragraph is briefly and logically states in a chronological order the facts on which the client relies. So basically the factual basis. So you set out the factual basis of your demand in the second paragraph. Which facts should be accurate? Don't don't exaggerate facts. Yeah, so you're just going to tell them as they were told to you by your client, and then consequently, this particular paragraph, the one for factual basis, the third one should be the legal basis. Yeah, legal basis. You're trying to marry now your facts and the law. For example, let's say it's an accident matter, and you want to ask this guy for monies which your client incurred at the hospital because of their reckless driving along Magadi Road. So in the legal basis paragraph, you will be telling them that actually your claim is premised on negligence, which allows compensation if the person has suffered any harm, but you'll shortly see that. And then your last paragraph is conclusion. So your last paragraph is conclusion. What goes into your conclusion includes the demand, and the consequences of what will happen if the demands are not met. So ideally, what you do in your last paragraph, you tell them, therefore, this is our demand. If you don't make good our demand, then we are going to go to court without any further reference to you. So your conclusion paragraph has the demand and the consequences of not complying with the demand and the timelines for complying with the demand. And then you proceed and sign off your letter, your demand letter. So I'm going to project a copy of a demand letter very quickly. Let me share a copy of the demand letter. We use that to discuss, because if at all, if you see a copy, you'll be some of the times the examiner asks you what are the omissions in this demand letter, what has not been done correctly in the demand letter. So your demand letter has this particular, it has a letterhead, but a very simple letterhead. Don't start drawing logos. You don't have that time. So usually your first paragraph, what goes into your first, your letterhead is number one, the name of the firm. So let's say firm B7 Advocate LLP, where the firm is situated. This one is situated at 40 Suite, 4th floor, Hospitality Road, and then the postal address of the firm, and then it has the telephone number and then the email. So however, you don't have time to put logos, so just have that simple letterhead, and then you can underline below the letterhead for your work to be neat. Okay, so don't, if assuming you don't have this line, what would have ideally happened is your work won't have any, it won't be very clear where is your letterhead. So just draw this straight line just below your letterhead, and then consequently you have our ref, your ref, and then the date. I won't belabor the point because you remember this. And then if you're writing to an organization, let's say you're writing to a company, or you're writing to a hospital, or you're writing to a corporate body, you have to address the letter to someone. You don't send it to Aga Khan University Hospital. So ideally, you will address it, for example, in this case, to the Chief Executive Officer, Aga Khan University Hospital, or the Managing Director, XYZ Company Limited. So usually, if you know their name, you can actually put their name here. If you don't know their name, just write Chief Executive Officer, or generally the person in charge of that organization. So don't address a letter to an organization without a particular person, because this letter, it has to go to someone who will now address your demand. And then consequently, so this is the address of the recipient or the person you're sending the letter to. You put it there, including the postal address if the question has given you, the telephone number, email, and then dear sir or madam. And then you consequently have the reference over here. So you read, the reason why you've said dear sir or madam is because you don't know whether the Chief Executive Officer Aga Khan University Hospital is a madam or a sir. So just say dear sir or madam, because remember, you have to use gender neutral language. You can't say dear sir, that would be gender neutral. Assuming it's a madam, and then you've written here dear sir, they'll be extremely, extremely, extremely offended. In fact, they won't even respond to your demand letter. And then you have your re or your subject. Basically, your re has to be extremely concise. Don't have a very lengthy re, like, you're saying so many things. You're saying medical negligence by your doctor against Miss Alice Mora on 4th of June 2016. At your hospital where she was treated by Harrison Sewe. So what you do in your re, it has to be extremely, extremely concise. It just captures the essence of your demand. So if your demand, let's say you're asking for compensation because of medical negligence, you just say medical negligence by your doctor against Miss Mora. Otherwise, this is how you could do demands. The re easily. So you just start by the word demand for. So every single time you write demand for, you will have a very short re. So if you write demand for damages, or you write demand for compensation, or demand for apology, or demand for, so you could start with demand for, and then consequently write what you're demanding for, because in very simple words, because ideally in this demand letter you're demanding for something. Okay, so in this one, the re is medical negligence by your doctor against Miss Alice Mora. So let me give you the fact what happened in this case for you to contextualize very quickly. We don't have a lot of time. So Alice Mora visited Aga Khan University Hospital on 4th of June and consulted a gyna at the family planning clinic for an appropriate contraceptive method. She was advised that insertion of an implant known as implanon would be the most suitable and appropriate and will further protect her from conceiving for a period of 3 years from the date of insertion. Upon relying on her doctor's advice, Alice went through a medical procedure of implanting the implanon into her left upper arm under local anesthesia. On or about August 2016, which is shortly afterwards, after going to the hospital, Alice failed to receive her menses, and upon undertaking a pregnancy test in the same hospital, she discovered she was pregnant. Further tests conducted by the doctor confirmed that no implanon had been implanted in her arm after all. Alice has approached you as an advocate to represent her, and you have determined she has a reasonable course of action. Discuss with your firm and draft the appropriate demand letter. So in this case, those are the facts. Yeah, someone went to the hospital. Her name is Alice Mora. So after going to the hospital, she was advised that there's a contraceptive method which might will work for her. So she proceeded, and actually the procedure was done at the hospital. And then shortly thereafter, she was pregnant. Of course, that was tantamount to medical negligence. That's why our re here is medical negligence by your doctor against Miss Mora. And then you proceed, and so this is what you call the introductory paragraph, where you're basically introducing who are you, yeah, where are you getting your authority from to write to us. So you would say the above matter refers, full stop, we act on behalf of our client Alice Mora, who has instructed to address you as follows. Do not say to address you as here Randa. You know that very, you just want to say here Randa because you're used to saying it every single time. If you say here Randa, there in after in this unit, you'll actually the examiner might not mark your paper. So make sure you don't use such language here under, there in after, as illustrated, therein. Okay, don't say those things. Okay, just you'll use them elsewhere, but in a minute, just use simple English as follows, and then you start telling your story. So paragraph 1 is the factual basis paragraph, where you're saying basically what happened, not in exact words, verbatim as in the question. So just paraphrase it. For example, on 4th June 2016, our client consulted Harrison. By the way, I'm not going to do this verbatim. So this is basically your factual basis paragraph. You're just telling them what has been happening. Someone came to your hospital, our client came to your hospital, they were treated by your doctor, your gyna, and consequently they have now conceived. The second paragraph is equally factual because there are quite the facts are quite many, so it was necessary to, when we discuss that topic for effective paragraphing, you can't have a very lengthy paragraph. For example, assuming that we put this everything here, serious. So what you do, you put that paragraph in your next paragraph, or your next, if you have another, whatever factual, but if you have other things you want to say about the facts, you just put them in another paragraph. If there were so many, don't just force them under one paragraph, and then the paragraph becomes extremely lengthy. And we say the problem with lengthy paragraphs is that, number one, your client will actually strain a lot, or whoever is reading this will strain a lot. So you have to start a new paragraph where the first one is already lengthy, or it seems like you've said enough in the first in this particular paragraph. So paragraph 2 and 3, they're both factual paragraphs. We continue to explain to the hospital what this means to Alice, because this unplanned pregnancy has caused her emotional distress because she wasn't psychologically prepared to have another child. The pregnancy has interfered with her career aspirations because now she has to defer her education, and furthermore, she was not in a financial position to comfortably raise the child. You see, these facts are not in the equation, but you just say that she's actually disoriented because she didn't have any plan of having a child, and then consequently, this is your legal support paragraph, where you're saying that your doctor owes a duty of care to our client. So ideally, if you say that, it shows that your course of action or your claim is premised on negligence, what you actually said in your re. So you tell them that your doctor owed a duty of care to our client and to provide services with reasonable skill, which they didn't do. Ergo, our client has suffered has suffered a lot of mental torture. And then you can mention Article 43, which provides for highest standard of health for every citizenry. Yeah. So that's your legal basis paragraph, very short, because every single time you're making a demand letter as an advocate, it means you have some sort of a claim in law. Yeah, ultimately you can approach a court of law if this demand is not made good. So this paragraph is basically legal support. You're telling them, by the way, you know, we're not asking for a favor from you. Yeah. In fact, your doctor has the responsibility of providing reasonable and standard health services to our client, because they are mandated by Article 43. And then consequently, this is equally legal support. You're telling them about Harrison Sewe is an employee at the hospital, and therefore there exists an employee-employer relationship, and therefore the hospital is vicariously liable for the negligent actions performed by the doctor who works there in the course of his employment. So this is equally a legal support paragraph. And then the conclusion paragraph, the last paragraph, where you're telling them our instructions are to demand admission of liability and paid damages suffered by our client due to the unplanned pregnancy as follows: pain and suffering resulting in mental anguish, huge financial implications because, of course, this child needs money, yeah, antenatal care and delivery services, any future expenses relating to that care, and the bringing of the child up, they attain the age of 18, because the child is going to need school fees, they're going to need clothes, food, shelter, you know, such things. So you're asking the hospital to cater for the expenses of the child up until they attain the age of 18. And then this other paragraph, you're just telling them the consequences of not making good this demand. You're basically telling them, take notice that unless we receive your letter of admission of liability, then within 7 days, we are going to institute legal proceedings. So two things here. Number one, you give them time within which to comply, because if you don't do so, they might not even respond. And you might not know now at which point to move the court. So you give them 7 days, and then you tell them what will happen if they don't respond within the 7 days. We are going to go to court and institute legal proceedings for compensation. So ideally, that is what will go into your last paragraph. If the paragraph becomes lengthy, because this is actually the conclusion paragraph, this particular paragraph highlighted and the other one, both of them, they are conclusion paragraphs, but if it becomes too lengthy, you can always go to the next paragraph and complete. And then you sign off your document, yours swiftly, whoever, and then you write your name, the person who was drafting this letter, Subira Karue, managing partner for Farm B7 and Company Advocates, and then you CC your client. Yeah, so that's how you do a demand letter. Let me see whether I can access that question for this year. In the meantime, we can ask questions. I want to project a response to a demand letter, and then we look at that question. I've been sharing that paper for 2023, but somehow I don't have it on my phone. I mean on my laptop. So let me just check it very quickly as I get the response to demand letter. There is one I did last week. I'm not sure which one. There is one which is interesting. Let me just get that one. It was ultimately a suit was filed. So the facts of this one, a particular person, actually an advocate of the high court, they were walking on the road. Yeah. And when they were walking on the road, they were attacked by a dog. Okay. Allegedly, they were attacked by a dog. So after they were attacked by the dog, they were like, you know what, you were attacked by a dog. So they wrote a demand letter to the client, the owner of the dog. They told the owner of the dog, I was beaten by your dogs. So pay me, okay? Pay me. I went to the hospital, I spent this much. Pay me back my money that I spent at the hospital being treated for the dog, for the bites, yeah, for the dog bites. So consequently, this was our response to that letter. So it has a letterhead, and then our your ref, your ref, and the date. Attention, this is because we knew the advocate who had drafted that letter. The demand letter, just pick their name, and then you put your attention, because if it goes to the law firm, you want this letter to be specifically directed to a particular individual, and then you know it's a madam, yeah, because you have their name. So it's dear madam, and then the re. So your re for a response to a demand letter, you can couch it. You have to make sure you're not implicating your client. You can't repeat what was in the demand letter. For example, if you're responding to that letter for Aga Khan University, you can't say medical negligence by our doctor. You can't say that in your response to that demand letter. So usually you try to absolve your client of any liability. For example, here it's a demand for refund of the purchase price and other costs. Oh, this is not for the dog. This is another one. Let me get the one for the dog. This is another one. This is another one. Or maybe we could let's start with the one for the dog, because I've already told you about that one. You have facts already. So let me share that one. For the dog. So what happened is this particular person still went ahead and filed a case. Anyway, so the re here is alleged dog attack causing bodily injuries to Miss Edna. So if you put it, oh, you guys can see. So if you put it like that, then ideally it means, you know, you're not saying there was a dog attack. There would be a difference if we said, if you put it like this, dog attack causing bodily injuries to Miss Edna. So this is how it was in the demand letter which was sent to the client. So you can't say that. You can't say dog attack, because this ideally means you're implicating your client already. If your re is dog attack causing bodily injuries to Miss Edna. So how you do it, you say alleged dog attack causing bodily injuries to Miss Edna. And then you consequently now tell your story. Yeah, or you just say your facts, because ideally at this particular point in time, you're giving your own version of the story. You don't believe, you're not agreeing entirely with what this person is saying in the demand letter. So in your response, what you should focus on is you should have some sort of a defense, yeah, but you're not telling them this is a defense. So you're using some facts to show that you actually have a defense in case they decide to go to court, because a response is meant to dissuade the person from going to court, yeah. So you tell them the above matter, and your letter dated 29th December 2022 refers, because you already have a letter which you're responding to. So you tell them this matter and that letter which you sent to this particular client refers. We have been retained by Ms. Rispa Maura. Hereinafter, don't say hereinafter, yeah? Don't say hereinafter. You could say God. I'm not sure what the synonym is, but a simpler word, and not hereinafter. So you could use any other, you could use something else who has instructed us to respond to you as hereinafter. Say as follows. Don't say, you know, this is a letter that I did. So you can say as follows, and then you proceed and now tell your story. Now, for example, for this particular case, our defense was that these dogs don't belong to our client. In fact, they do not belong to at all. In fact, our client is a stranger to any dogs. In fact, our client is allergic to dogs, you know. So our defense was these dogs don't belong to our client. You know, a dog doesn't have a tag at its yours, you know, because these dogs actually came from an apartment block where so many people live. So why would you say these dogs are our clients, you know? So our point of defense was that our clients informed that contrary to your client's assertion, the alleged dogs neither belong to our client, nor are they registered in our client's name. Ergo, there is no liability and course of action that arises in favor of your client against ours. Don't say this, don't say ergo, don't say that. Use a simple words. Just say therefore. Go is synonym for therefore. So just say therefore. And you could also don't say and or. This will be deemed as archaic because remember legal language is unintelligible. So say something else. There is no there is no liability and course of action. Okay, but don't say and or. That's actually prohibited. So I'm showing you what not to do. Okay, at the same time showing you what to do. So despite responding that these dogs don't belong to our client, we still proceeded and responded substantively to the letter, to the demand letter. So you proceed and, you know, you have to have, you can't just say, you can't respond without a defense in the back of your mind. Yeah. For example, here, the defense was, you know, there is a defense in negligence. Usually it's called volenti non fit injuria. It basically means you're the author of that misfortune that you suffered. In fact, you're the one who exposed yourself to the risk. So ideally, in this case, that was the defense. So every paragraph was aimed towards showing that your client who was beaten, allegedly beaten. Imagine they were chihuahuas, yeah. This client who was beaten by the dogs, yeah. that's up to them because they expose themselves to the risk. So this particular paragraph shows that your client saw some dogs but failed to take any measures to mitigate any risk of attack. There are other pedestrians on the road who are not attacked by these dogs. Your client saw some strange dogs that were behaving aggressively approaching her, but in her own frolic, chose to ignore the dogs instead of trying to avoid the dogs. Your client having sighted the dog, a lot of repetition there, but you get the gist, okay? And then consequently, there are some discrepancies in her document. For example, in a P3 form, P3 form would have been written dog bites. These guys, this particular, you suffered injuries because of dog bites, but the P3 form was written verbatim. Unfortunately, even the demand letter, it was written the client fell on the ground screaming. So ideally, your injuries were caused by the fall, not by any dogs. You fell. No one pushed you. The dogs didn't bite you. You fell. And the P3 form equally stated that this particular her injuries was because of falling, not because of any dog bites, okay? Because ordinarily a medical exam would have revealed that injuries were as a result of dog bite, which was not the case in the instant demand. So you tell this, okay, now for a response to a demand, just remember to have a defense. Yeah. You can tell your own version of the story, what you believe is true. Or number two, you can just state, have a defense in law because you have defenses for all the course of actions. So have that defense and then you use the facts to support that defense without saying that's the defense. We haven't mentioned anywhere this is volunteer and fit injuria, but we're just letting them know if you go to court, then volunteer and fit injuria is our defense because your client exposed themselves to the risk. Okay, and then consequently, so the remand letter, this response is quite lengthy. Let me show you another one, and then you tell them our clients, in fact, reserves the right to sue yours for maliciously tainting her as reckless. We will not be making good any of your demand. Kindly advise your client accordingly. So you can tell them we won't make any good any of your demand. We are not going to do anything. In fact, just do whatever you want. I think you've seen those demand letters. Like it has one sentence, yeah. It is written, proceed and sue, and nothing else. So your last paragraph in the response, you're just telling them, do you intend to satisfy their demand or you don't intend to satisfy their demand? So basically in this one, no one was ever going to make good any demand because in fact this is not the owner of the dogs, so there is no way they're able to make good your demand. And then you sign it off, yours faithfully, the name of the advocate for, and then you see the client. So that's how you do a response. Let me share another response. So the gist for responses is just having a let's do one more response and then we do the next. We do an exam question for demand letters. Okay, so this one, the brief factor, what happened is there was supply of some green coffee beans for purposes of export. They were supplied to a particular company, which company usually exports their coffee beans. So when the coffee beans were exported, they hit the European market. But after hitting the European market, it was discovered that the coffee beans are contaminated with staples, like those staples for stapling books. Yeah. So immediately our client was informed, and then a demand letter was sent, and they were told, you know what, your green coffee beans are contaminated, and they were asking for compensation to the tune of I think 300 million, yeah, around that figure, because the beans were a lot. Okay. Anyway, be that as it may, our defense here was that, number one, usually these particular the coffee beans are not labeled, they don't have tags. So they buy from so many farmers, from so many suppliers, yeah, but they don't have tags. Like everybody brings their coffee beans to, but they take them to industrial area in a go down, and then they are collected from there, and they do not have any tags. So how did you know these were our clients' coffee beans? Yeah. So the defense was along those lines that, you know what, you guys, coffee beans are actually they're taken to Bolloré. Bolloré is the go down, and then they're collected from there. So essentially, if they're at Bolloré, everybody brings their coffee beans at Bolloré. There are no tags. How do you then say that the contaminated ones are our clients? And in fact, they had roasted like half of our clients' consignment. And then when they were halfway, they were like, they are contaminated. Of course, during processing, they would have seen that these coffee beans are contaminated, but they even exported them. Yeah. the roasted beans, but they're saying, you know what, I think it was just a ploy to get some money from our client. So how you couch your re is number one, make sure you're not implicating your client. So for example, this one will say demand for refund of the purchase price and other cost for supply of alleged contaminated green coffee beans, you know. So you just say alleged because this is not true entirely. In fact, anyway, it wasn't true. So you consequently proceed and tell them that the above matter and your letter dated, because there is a letter which you have dated 22nd August 2023 refers, and whose content you have duly noted. Don't say that, just say that in your exam. The above matter and your letter dated 22nd August 2023 refers. And then you proceed and tell them who has instructed you, that introductory paragraph. So you tell them we've been instructed by Peter Minor, the managing director, Roy's Warmdyke Company Limited, and then you proceed and tell them your story, that our client got an email correspondence that their offer sample, usually before you take the coffee, you have to bring an offer sample, they test it, and then if it meets this required quality, then they ask you to bring coffee beans to them. So they were told that actually the offer sample was in tandem with the quality. Therefore, our client was to proceed and package 120 bags of green coffee beans, which they did. And they were supposed to be collected by their client at Bolloré Transport and Logistics. So on the appointed date, coffee beans were taken there. So you proceed and tell your story because it has to have coherence. Coffee beans were actually taken there at Bolloré. To note, at Bolloré, other suppliers drop their green coffee beans there, which are later collected by Argent Cargo Logistics Limited. So at this point where the bags are mixed up at Bolloré, so you cannot at a later date, 30 days later, tell me these were the contaminated. How do you know these were the clients' bags and they don't have any tags? Yeah, it's because they are mixed up. So many people have, these bags collected from Bolloré, from various suppliers, and are not tagged, yeah, until they are in the warehouse where they are going to be processed for purposes of export. So you proceed, tell your story. I don't want to do this verbatim because the facts will be different in your case. So what you have to remember is you have to have a defense. That's number one. And then all your paragraphs, should be aimed at making sure that you dissuade the person from going to court or from believing they have any claim against your client at all. Yeah. So your client received this particular contract, because there was a contract, they were supposed to raise any concerns regarding quality within 5 days from receipt of the coffee bean, but no concerns about quality were raised there. They were only raised afterwards, 30 days later, even after these goods had been transported. I mean, the coffee beans have been roasted, part of them, and they had been processed and packaged and taken to Europe for purposes of selling over there. Yeah. So you tell them the last paragraph, premised on the foregoing, our client will not make good any of your unfounded demands. Kindly advise yours accordingly. Additionally, no privity. There was another guy called Moye. In sooth, our client reserves the right to sue yours, and then yours faithfully you sign off, and then you see the client. So a response is, remember to have a defense. Don't just deny things without a defense. Just structure a defense in your mind first, and then you proceed and write. Okay. So let me check an exam question. Okay, let me know whether you have any questions as I try to get the paper, the 2023 paper. Let me share it on the group as well, for the benefit of those guys who don't have it, very quickly, and then we go to legal opinion. I want us to do a question first, because God, who has those papers? I keep losing mine. So Lord. Okay, I have it. CLE March 2023. Just allow me to share it very quickly. So that particular question, let me read it, and then you guys will to save on time, because I have a hard copy here. So that question asked, it was question 1, March 2023. It asks, there is a story there. This one we have to project. It asks, identify 4 errors and omissions in the demand letter God. Let me see whether I have it. Let me see whether I have it. Who has that paper for March 2023? Please share it via my email. That will be really, really helpful. Will save a lot of time. But let me see if I can check it from my phone. Sorry, March 2023. God, I can't find it on my phone. Okay, so the exact question, March 2023, question 1, look at that. I'll try to check it before we finish the class and look at it. And then that question asks you to respond to the demand letter. There is a demand letter there, and then you're told, assuming your client, Mjeurisana, has been maintaining the minor, draft a response to the letter. That's question 1. Okay. All right, so let's go to the second document, legal opinion. I'll share the notes briefly, and then we look at. By the way, if you have that, it's on the group, but I think I deleted my text from the group. So if you can find it, please share. That will be very, very useful. Let me share the notes. We go through the notes, and then we look at a legal opinion. So a legal opinion is used to communicate to a client, basically advice. Yeah. And usually writing opinions, we have two types of opinions. An opinion can be, number one, can be done through a legal opinion, or what is called a letter to the ordinary one, or it can be through an office memorandum. Okay, so ways of rendering a legal opinion, it's either by a letter. By a letter, this is where you're dealing with a client or a different firm. When doing a letter to the client, to keep it very simple, you've already restated that. And then number two, you can render a legal opinion through an office memo. So you will render a legal opinion using an office memo, where the person who's requested you to do this legal opinion, or they've requested for your advice, they are in the same organization with you. Yeah, so let's say this is your managing partner, your pupil master, the head of department. Yeah, so they request you to do a legal opinion. So usually you use an office memo. You don't do a letter if it's within the same organization. So those are the two ways of rendering legal opinion, either by a letter or an office memo. So I want us to start by a letter. We look at the content, and then we go to the actual letter. So the content which go into your letter, where you're rendering legal opinion through a letter, you use the process called IRAC or FIRAC. Yeah, you remember FIRAC? So usually FIRAC means FIRAC. F is facts, okay? And then I, issues. And then R is rule of law or application of the law. And then A is analysis. And then C is conclusion. So it's FIRAC. Let me project FIRAC. So usually, let me project we discuss using the legal opinion. There is a really good legal opinion which I have. I remember I was taught LWD by, God, what was her name? An extremely, what was her name? I forget her name, but God, hi, it's been a while. I'm growing old. Yeah, but she taught me LWD, and I remember in that class, she said this legal opinion was extremely, extremely, extremely good. And she's been teaching LWD forever. So let me project that legal opinion. So a legal opinion is a way of advising a client. So you just need to remember the content and what not to do in a legal opinion. So let me share it. Okay, here we are. So it has a caption, a letterhead. Everything has a letterhead. All letters have letterheads. All letters that you'll ever do, they have a letterhead. So you have a letterhead, and then you have your re, and then the date. As we did, like everything remains the same. So these are legal opinion. Remember those facts that you were discussing, yeah? Where Mora went to a particular hospital, and then they were told a particular contraceptive method will work, and then shortly thereafter they were pregnant. Yeah. So these are legal opinion advising the hospital or advising the chief executive officer of the Aga Khan University Hospital on the integrities. Okay, so they received the demand letter. They asked you to advise on the contents of the demand letter. So it is addressed the chief executive officer, Aga Khan University Hospital, dear sir or madam, because you don't know the gender. Remember, when you don't know the gender, it's dear sir or madam. and then a legal opinion, which is taking the format of a letter to your client. So usually the easiest way to couch it, the re, is by starting with the word legal opinion. You remember for the demand letter, you just say demand for. And then for a response to a demand letter, you use the word alleged. Yeah? It's saying alleged medical negligence. So legal opinion on claim for medical negligence against Alice Mora, because it's a legal opinion, okay? And it has to be very, very concise. Yeah, very concise, very, very precise, straight to the point. So you have the introductory paragraph here, where you're just saying who you are. I mean, where you're coming where is this coming from? Did I ask for this legal opinion? Because a legal opinion is a chargeable document under the ARO. You charge for these. So you're telling them, I am giving you this opinion. I'm writing to you because you instructed me to write to you. So you could say we make reference to the above subject matter and further to the demand letter dated 9 September 2021 and wish to render a legal opinion as follows. Our legal opinion as follows. So it doesn't have to read like this exactly. You could say the above matter refers and our meeting in our chambers on 3rd of July 2023, and pursuant to that meeting, we wish to render our legal opinion as follows. Having reviewed maybe the law, legal principles, we wish to render our legal opinion as follows, and then you tell them what you found out. So for legal opinion, it has after this particular paragraph telling them where you're coming from. I mean, in terms of, are you advising us, me, because you had a meeting, I asked you to advise us, or I brought to you a demand letter, or I brought to you a sale agreement. I asked you to write to me advising me on the content. So basically, you will have that paragraph. After that, you have to have your subsequent paragraphs will have to have subheadings, okay, in a legal opinion. For example, in this one, remember you're using FIRAC. So the first paragraph is factual basis, factual context, background, any word that shows these are factual basis. You proceed and tell them the story. The story is the same, yeah? However, as you're writing your legal opinion, it's in the first person. You're addressing your client personally. So you would say on 4th June 2016, Alice Mora consulted a gyna at your family planning clinic, okay? So you're going to address them personally. You're going to tell them at your clinic, at your hospital, yeah? And then you tell them she was advised that insertion. You just tell them what happened in those facts that we are looking at. She was told that insertion of an implant known as Implanon would effectively prevent conception within 3 years from the date of insertion. However, in 2016, Alice was pregnant, okay? So that's why she wrote to you a demand letter. So the first paragraph is basically, don't assume the client knows the facts. You're going to tell them the facts, as of course they're the ones who told you, or you're picking these facts from the demand letter. And then your second paragraph, it's issues for consideration. And of course, it has to have a subheading. So you write like that, issues for consideration, that they carry a ruler. This unit, you'll need a ruler. Either for drafting the bill, you'll need to underline your margin, or for drawing a nice letterhead, you'll need a ruler. So you write issues for consideration, underline, or you write with a black pen. Oh, that's too much. So you could just underline or show that it's a subheading. And then you proceed and tell us that the following issues will fall for consideration. Usually issues for consideration are dictated by your facts. From these facts, you're going to pick your issues. You don't pick issues from the blues. So you read these facts and then you pick your issues from these facts. For example, what to your mind, what would be one of the major issues is whether you guys are vicariously liable, because it's your doctor, yeah, your employee who works there, and then you'll ask them whether whether there was breach of duty, because that is what basically this fact presents those issues. So usually you look at the facts, and then the facts will dictate what issues you'll have. In your exam, don't have more than 3 issues. By the way, if it's possible, just have 2. Just have 2 issues. Don't have 3 issues, yeah, or more than 3 issues. And I'll shortly explain to you why. Because you'll need to analyze each issue independently. So you, for example, here the issues which fall for consideration include issue number 1, whether the doctor was negligent. Number 2, whether the hospital is vicariously liable for the actions of the doctor. They're in form of questions. Issues are in form of questions. You have to put a question mark there because they are questions. And then issue number 3, whether the patient is entitled to compensation, because ultimately, remember, Alice has done an entire demand letter asking for compensation. So So you'll be advising whether this Miss Alice Mora is entitled to compensation. And then, so that's the second part, issues, because fine rank is FI. So after your issues, by the way, restrict yourself. If it's possible, two issues in an exam, okay? And then unless it's very necessary for you to have a bad issue, then try restrict yourself to two issues, two major issues. And then the other subheading is rule of law. So rule of law in our FIRAC is the third thing, or the third paragraph, quote unquote. So your rule of law, in your rule of law in a legal opinion, do not proceed and start analyzing the law at this point. So what you're going to do simply is just say in our analysis, the above issues, and in our analysis of these issues identified, reliance is placed on the following applicable laws. And then you say Constitution of Kenya, you can proceed, you can just maybe have A, you say Constitution of Kenya, and then you have B, treaty and legislations. Don't explain anything here. Don't start telling us the Constitution of Kenya and Article 25 provides for 43. Don't do that. Don't do that. So what you're going to do is just mention there that document. You could just briefly, for example, say the applicable articles would be say 25, 43, and this is just an example 62. But do not say what they state. Do not proceed and explain, okay? Because you'll have repeated yourself when you're doing your analysis. So what you do here in your rule of law, you just mention there the laws that you're going to rely upon. We have some cases here. In an exam, you might not have any cases, highly likely, because maybe in that area you have no, maybe it's it's an area where you don't have any cases. Health Act, this is supposed to be up here. And then cases. So you list your cases. If you have cases, you can list the cases. In an exam setup, you might not have a lot of cases. You know, right here, these cases are so many because you have time to research. Otherwise, you might have one case, so you have no case at all. If you don't have any case, then it's allowable, it's okay. So in your rule of law, just say now analysis of these issues, reliance is going to be placed on the following applicable laws: Constitution of Kenya, treaty and legislations. You mentioned those the treaties or the legislations that you're relying upon, and then the cases. So you could say negligence being a common law tort, we have relied on the following case laws, and then you list the case laws. Or if you don't have any case, then it's okay. Don't have any. I mean, don't force a case or don't guess a citation. Just leave it like that. And then that bit of your, I mean, this should be the fourth analysis. Analysis is the fourth part of your legal opinion. And in your analysis, basically what you're going to do, let me show you what you do. In your analysis, of course, in an exam, you can't copy paste, but basically you copy paste all these issues. So your analysis, you copy paste all the issues, and then you proceed and paste them here in your analysis. All right. So you're going to analyze each issue independently. So each issue independently, each issue. So you're going to analyze each issue independently. You're not going to analyze, if you have 3 issues, you'll have three issues to analyze, okay, in your analysis. So what you basically do in your analysis, for example, let's say issue number 1, you restate the facts very briefly. For example, whether the doctor was negligent, you just restate those facts very. You will say that Miss Mora attended to your hospital or was treated at your hospital by that particular doctor. Yeah, and then you say that the doctor is actually the one who told them that this particular implant will work. And then after doing that, you marry the law and the facts. Okay, so you state these are the facts. Your doctor said they're able to do this, it will work. And then consequently, you state what the law provides, and then you marry the two, the facts and the law. Yeah, because now you have to show the link between the facts and the law. You have to say now, this action by the doctor of telling the client that they won't get pregnant, yes, they are pregnant now. What is its implication in the law? Or in the instant case, the instant legal opinion, or rather, what is the place of a doctor who misleads a client in law? Basically, that's it. So you try to relate the two. For example, let's do an actual one. So whether the doctor was negligent, which is issue number 1, we start with analyzing that. We'll say, let's say medical negligence arises when a medical practitioner by acts of omission or commission breaches the duty to take responsible care with regards to a patient. And then you proceed and tell them that these claims usually are determined on principles in Don Hogg versus Stevenson. There is a 3-tier test. So basically the law, ideally, you would have said very brief facts here, brief, because you want to remind them what your doctor did in a sentence, and then you proceed and tell them what is the law. The law is Don Hogg versus Stevenson, and then you conclude that particular. There is a lot of cases here, because guys are time to research, and then you proceed and conclude that particular issue. Yeah. So the conclusion is now in this particular case, is the doctor negligent? So you don't leave the question hanging. If the question, your issue was whether the doctor was negligent, you have to answer that in the affirmative or negative. So you have to conclude an issue after showing your very brief facts in one sentence, your law, marrying the law and the fact. You have to proceed and conclude and answer that question. Yeah. So you, for example, here, the doctor was expected to give Alice the best standard of care. He was to act within reasonable standard expected of a professional doctor, as discussed above. The doctor did not do that. Yeah. And therefore, this, the question is answered in the affirmative. The doctor is negligent because he was not able to accord Alice Mora ordinary care. Yeah, he didn't accord Alice Mora ordinary care as he was supposed to. So ideally, that's how you do your analysis of issues. You start with very brief facts, and then you go to the law. You marry the law and the facts. Marrying the law and the facts means that you say that failure by your doctor to advise Alice Mora on a suitable contraceptive, then that is tantamount to negligence. Or making Mora believe that this would work, yet it didn't work, that is tantamount to breach of duty of care, as laid down in Don Hogg versus Stevenson. Yeah. So basically, that's how you do it. As you're doing this, your analysis, it comes with a lot of practice for you to be able to marry the law and the facts. Usually you do that in rulings, judgments, submissions, and legal opinions. You have to have done it. You have to have done it. It's not a simple thing, marrying law and the facts. It's very hard. So sometimes there might actually be a noticeable gap between your law and the facts. They're not connecting so seamlessly. Your facts should connect with the law. Yeah. So if you're saying the Don Hogg versus Stevenson, there has to be a duty of care, proceed and say this doctor owed by dint of existence of a doctor-patient relationship, then there exists a duty of care. Number two, this particular guy misled the client, so there was breach of the duty of care. Number three, harm was suffered by Alice because Alice is pregnant now. She didn't plan for that, so she has to incur expenses bringing up an entire child. So that will be the breach occasion to the client harm. So we won't discuss all other issues. You just have to understand how to analyze the issues. Remember facts, law, marry the law and the facts, and then conclude that issue. Answer that issue, basically. Say whether you're answering it in the affirmative or in the negative. So you proceed and do that for each issue. So you're going to analyze each issue separately. And then after analysis, you go to conclusion. So conclusion is your last part in a legal opinion. So conclusion, you're just telling them now, finally, you doesn't need to have this in your paper. Of course, you don't have the luxury of having footnotes, but sometimes guys do footnotes for ease of reference by the client. So conclusion, you're telling them, wholesomely, now what next? Because you've told us our doctor is negligent. What do we proceed and do next? So you tell them, from our analysis, we are of the opinion that Alice has a valid cause of action against the gynecologist, in particular, the total medical negligence. Since your doctor is your employee, you're vicariously liable for his actions. And then now you don't leave it at that. You be helpful to the client. You have to tell them now, what do they do? Because their doctor is negligible, is liable for medical negligence, and they're equally now liable because of vicarious liability. What do they do? So you could tell them these are the possible options that you guys could rely upon. Number one, an out-of-court settlement, or number two, mitigate damages in case of litigation. So an out-of-court settlement means you're going to approach in an exam setup. You don't have the luxury of doing this. This is too much. You could do it. Let me show you how. So you can say, I want to delete it for you to have a clearer picture. Okay, so this is how you do it. You tell them in the light of the above. These are the options that you guys have. So you say out of court settlement, and then you explain what out of court settlement entails. You could tell them that Article 159 of the Constitution provides for settlement out of the court, and then you tell them modes which you would use include arbitration, mediation, conciliation, and then you tell them you go to the next one, mitigate damages in case of litigation. You could tell them you can wait to be sued, and then upon you being sued, then try and mitigate the damages in that particular suit. Yeah. And after telling them the two suitable methods, or I mean, two options, whatever options they have, you have to tell them the best, in your opinion, as a professional, what is the best option. So you could tell the hospital, in your opinion, an out-of-court settlement would be the most suitable option. So after advising, you could have a myriad of options. So you have to tell your client which is the most suitable option, because you guys,
are you presenting?
but there has to be the most suitable option. So you tell your client the trying out of court settlement is very clever. Waiting to be sued is not a very clever idea, because you guys will even pay costs. Okay, ideally you pay costs, you pay legal fees, you pay filing fees at the court. That the expenses are too much if you guys wait to be sued and then you mitigate damages. So you could try and explore an out of court settlement. This is because it is speedier, less expensive, and
Excuse
the relationship and the hospital. So
Lydia.
that's the conclusion. Conclusion. Remember to tell your client the options they have. If you have answered the question in the let's say you've told them you're negligent or you're liable, what's next for you? So those are your two options, and then you give them the most suitable option. And then your conclusion is always, if this particular opinion is not sufficient, then contact us. We can clarify, we can give you further information, and then you sign the document. You write your name and the firm of advocates that you practice at. So that's how you do a legal opinion. There's so many questions on legal opinions. Let me check.
Yeah, Lydia, question.
Let me check one.
Hello.
As I want to, you guys you can ask questions. Just remember you use FireRack. Okay. Office memo takes an entirely different format, but in the meantime, just a quick menu. This ATP 103. When I was at KSL, I printed past paper questions. I was so ambitious. Yeah. Okay, let's start with this one. Let's start with, this is Kitambo, November 2010. CLE wasn't even getting papers at that time. Okay.
Lydia.
For July 2015.
Lydia, can you hear us?
Yeah.
It's someone who has been trying to talk and you haven't heard him.
Oh,
really? Answer the question.
Oh, my volume was so low on my laptop. I had reduced it during the day. I forgot to put it back on. Yeah. But I can hear you now.
Can you hear us now?
Yeah, loud and clear. So sorry.
No, we were asking if you were presenting anything, because the screen was blank.
For how long?
But we have been seeing, maybe he can check from his end. From my end, I could see.
Let me project it again. This is what I had projected. I had projected a legal opinion. So we were discussing the content. We said it has the letterhead, but for your case in an exam, don't start drawing. You want a logo. Yeah, you want a fancy letterhead. Just write the name of the firm, the postal address, the exact location, and then you write the email and then the phone number, and then that's it. Then you address it to whomever, and then it has the re. I believe now you can see. Okay, let me do one thing first as you're looking at this for guys who couldn't see. I want to get a legal opinion. Okay, so for demand letter, look at July 2015, question 4. July 2015, question 4 asks guys to draft a demand letter, to do a demand letter. And then the other question is drafting a bill. Okay, let's do this one. This might be interesting. Okay, let me just open it. July 2015. Oh God, I was supposed to share a link for the past paper questions. I forgot. So remind me, please, after the class to do so. So let me share the question. We look at it. Everyone has to participate. So this is July 2015. This is the year CLE started setting questions. Yeah. This is question 4. Imagine it had sections. Yeah, I know, right? This is an attachment for purposes of doing a case brief. Is this paper complete? Section B. Yeah, it is complete. Here. Question 4A. Here, question 4A. It asks you, there's some stories here. Agnes Otieno visited Aga Khan University Hospital and consulted a gyna. So this is the question you are answering. Well, just attempt and draft it without checking the answer. Okay. So drafting that demand letter, it's the same fact, yeah. The gyna at that hospital, the issues of implanon, it's 7 marks. Okay. And then there is another one. There is another one. There is that attachment. Okay, this is the other year. The next month. Question part C. Oh, no, this is drafting a bill. I don't want to discuss a bill if you've not done it in class. So let's get okay, let's go to November 2015. So just write these questions pahali utazidraft baadaye. You know writing is very hard. Like with a pen. Hey, nakwambia, I experienced it firsthand, the struggle. Yeah. You know the content for a demand letter, but now you're supposed to draft that entire thing, and it's a lot. You're supposed to draft it maybe in less than 15 minutes because you have other questions to do. And then you find yourself struggling because only ambia your friends vile unajua contents za nini na uwezi andika haraka. Okay, so this is November 2015. It equally has a question on demand letters, specifically question 4. Oh, good. Let's try this one. Yeah, sindio. So it asks, what is the impact of plain English in legal writing? Drafting in the light of the work of a practicing advocate in Kenya. So that is how plain English questions will be tested. No one will tell you what is plain English. Okay, there has been a question on what is plain English, but no one ever asks qualities of effective writing. So this is how the questions are tested. Why is plain English important to advocates? What would you say? And it's 8. 8 marks is a lot. You have to say a lot. So you could type on the chat box question 2B. What is the impact of plain English in legal writing in the light of work of a practicing counsel in the country, in Kenya? So this was what I was looking for. Question 4A, it asks you, identify and explain the functions of 5 key parts of a demand letter. See, this one you will comfortably answer, but type on the chat box. You might equally win yourself a course outline. So identify and explain. So you will be stating the functions. You will start by defining what a demand letter is, and then consequently you number. Yeah, you would say the first part of a demand letter is the introductory paragraph, and then you say the function of an introductory paragraph. You go to number B, factual basis paragraph. You explain the function of that paragraph. You go to C, legal basis paragraph. You explain the function. And then you go to the conclusion. You explain the function of that part of a demand letter. And then the second bit asks you to draft the demand letter. So there's so many questions on drafting demand letters. So my assumption is you guys will look at it. However, you guys highly likely you'll draft a contract of sale or a legal opinion. So let me get legal opinion. Sahizi tu. Unajua na peruse. Okay, there is a question where guys were supposed to draft a letter, just a plain letter. The question is November 2018, question 3A. Yeah, November 2018, question 3A. It was draft a letter. Okay, after to project. Sindio, November 2018. Let me check that. By the way, now mta one mute mseme kitu. November 2018. By the way, you might think you don't need these things, and then you're told to do a legal opinion at the law firm, and it's your first day in your pupillage. Yeah, you know, that first impression. Yeah, so if you remember what goes into your legal opinion, and then you do a perfect legal opinion, and you have time to research, you'll leave a permanent mark. Yeah, people want you to stay. You tell them you want to leave, wanakuuliza tuongeze ngapi. Okay, so this is a TP. God, should be a TP. Oh, what's going on here? Let me get the correct paper. I think there is some confusion here. Oh, okay. Whoever was scanning this saved civil as LWD. God, so how do we know where LWD is? Let me see whether I can figure that out. Okay, yeah, I've seen it. Let me project it again. Okay, so this one we are going to attempt and answer. Everybody is going to attempt and answer this one. So I'm going to scroll down to question 4. Question 4 here. It asks you, lawyers no longer communicate to lawyers. Parliamentary council no longer writes for small educated elite. The public and the profession are becoming increasingly intolerant of archaic and unnecessary complex legal language. Not only is poor legal language losing lawyers, their clients, but businesses that uses archaic language in their documents are losing customers to those who do not. The failure to use plain language costs society as a whole an inordinate amount of time and money. Poor legal language brings the profession and the law itself to disrepute. And then you're asked, using the context above, discuss the benefit of using plain and ordinary English to legal profession. Okay, so let's attempt this one. What is the benefit of using plain English in your practice as an advocate? Why is it necessary? In your own words, what do you think? Everybody could have, these things you don't even have to have read. You just think, and then you have the answer. Like, you know what plain English is, you know the answer. What will you say? I'm waiting for you. What would you say? Come on, guys. Evans, I know you are here. What would you say? What is the benefit? Or generally, what's the benefit of using plain English? For real, guys. For real. Eh? Come on. We don't know. Najua mko na answers. Higher. We could start with some. Benefit of using plain and ordinary language. Can you guys hear me? Yeah, I'm unmuted.
Yes, we can.
Don't mute. You could answer that question, just 1 point. Benefit of using plain and ordinary English. And we move to
plain English is easily understandable.
Very well. So in context of legal profession, why would you want to be understood easily as an advocate? Si rahisi vile tulikuwa tunafikiri. Okay,
can
go
we
on.
see can we say that it brings about clarity?
Yeah, it does. And then you could use examples. You could say, for example, your client is able to make informative decisions from your maybe legal opinions or from your client care letters. Basically, if your client understands you better, then essentially it means it even enhances your relationship. Yeah. So that's why you would want to be understood easily by a client. And then that point is too tired. The other reason you would want to be understood easily, especially now by the court, if you're understood easily, you're likely to get what you want from the court because they're able to understand your pleadings. They're clear, they're straightforward. The language is plain and ordinary. And therefore, you are able to get orders or whatever you ask from the court, you get because you're clear. So highly likely, if you're using plain English, ordinary language, the judge is able to comprehend what you're saying. Your message is passed across easily, and therefore you get what you want from the court without a sweat. Okay, so that's why you would want to be easily understood. What's the other point? We have 1 out of 4. Yani inakaa rahisi, ikifika siku ya kujibu si rahisi. What else? Guys, mnanyamaza kwa nini? You just think about in a law firm. Basically, if you're working in a law firm, or you're just in a law firm, even as a pupil, why would you use plain English and ordinary English? Guys, imagine I'm waiting for you. Is it Sam? Is it that you guys are thinking about it, or it's a tough question? Okay, let me get someone to answer. The list is here. Amakobe, your name is the first on the list. Answer. We do legal opinions. I want to project legal opinions. Guys, Lord, for real. Okay, so the other benefit of using plain English is in terms of the legal profession, you're able to save time, expeditious disposal of suit. Yani mmetulia tu type of the chat box. Hii swali ni ngumu. But hiyo siku mtajibu, si ndio? So you know the answers because it's actually, you just think about it practically. So I was telling you the other reason why you might need to use plain English, it's because or the advantage of being ordinary, it enables expeditious disposal of suits and saves a lot of time in court because everyone understands you. You won't start asking for, oh, I want to amend, yeah, because you figure out, good Lord, maybe you've missed something, or your sentences are too lengthy, or you don't have some particulars, so you have said negligence generally, and you don't have particulars in your pleadings. So being simple, ordinary, saves a lot of time in terms of court, and enables expeditious disposal of suit, which is in furtherance of administration of justice. Yeah, so that's why you will need to use plain English as well. Improved communication, easily everybody knows exactly what you at the law firm. If you're writing whatever, a memo to your pupil master, and you use a archaic language, they won't understand what you're saying. They'll have to they call you to their office, they ask you, what do you mean by the word prolegmnon? Yeah, so they'll keep on asking you questions regarding what you've written. But if it is plain English, straight to the point, then ideally it enhances improved communication at the office, and you're able to work seamlessly and equally save a lot of time. That's why you use plain English. Ultimately, you will get a lot of business because the client will be happy. You've been able to communicate, you're getting orders from the court easily. They understand exactly what you tell them. If maybe you're doing pre-trial preparations with them for their hearing, they understand what you're saying. So you'll be able to get a lot of business in terms of this client will be a return client, and they'll also bring other clients, because usually how you get work is through referrals. Yeah, so the list goes on and on. I believe that you guys will answer that question. I don't want to keep pestering you. So let me get a question on you guys will. I am 101% positive, sure, you're going to do legal opinion in your exam. Like, as certain as the sun will rise in the morning, you guys will draft a legal opinion. And you'll say, I told you. I asked you, you kept quiet. Okay, so what I'll do for legal opinions, I'm going to give you a question, okay? And then you'll draft it. And by the way, I'm here. You can draft it, send it to me. I look at it, and then I give you my unsolicited advice. So let me project one legal opinion question. I want us to draft an affidavit now. This is question 3, November 2019. Aya, tuende hapo. Na msijaribu kunyamaza. Do not. Aya, so let me get the question. It's 2019 November. Actually, no. I had not opened it. Okay, 2019 November. So make sure you do a lot of legal opinions because you will draft it that day. Yeah, and tell your colleagues, save them from struggling. Okay, you know, I told those guys for March exam, I tell them, guys, you guys will do a demand letter and a response to a demand letter. So they thought I don't know what I'm saying. Okay, so there's this question. The first question is key aspects of legal writing that have been ignored. So look at such. This one asks you to describe legalese in plain English, but I'm scrolling down to the legal opinion one. It's question 4 here. So usually the legal opinion question could be you draft, or it could ask you, it could be theory. Yeah. For example, this one here, question 4, part B, it asks you, explain your answer by discussing briefly why in each of the scenarios the document mentioned qualifies or does not qualify as a legal opinion. So you have to remember what is a legal opinion for you to be able to advise whether a particular document qualifies as a legal opinion or not. So as you're doing that, remember you only render legal opinions upon being requested to do so because it's a chargeable document. And number 2, it could take the format of a letter to someone who works outside your organization or just an external party or your client, and you could render it through a memo. Yeah, an office memo if you're advising someone who's within your law firm. So let me project an office memo. I had forgotten. I wanted to project an affidavit. So let's do office memo, and then we discuss affidavits. Let me get office memo. A very easy unit to pass, ndio. So unajua, if you pass if you are the best student, number 1, in any unit, you'll be given 50K. I'm not sure whether the amount was increased, but used to be 50,000 for each unit. Whoever has the highest marks in that unit gets 50K. And then after the 50K, you see those law firms that you guys like, they'll poach you. Those tier 1 law firms, they'll poach you, you start working for them just like that, effortlessly, without applying. So you can equally, try and score the highest mark in this unit. Sorry, let me get the document. So an office memo is it's a mode of rendering an opinion. Usually you will do it if you're doing it, you're advising someone who's within your law firm. Okay, and this unit format is very important. So if you're supposed to do an office memo, it takes a particular format. A legal opinion will always be FIRAC. It can't be anything else. And then a demand letter will have those parts that we've discussed, okay? So this is the office memo. You can use this office memo. An office memo, it has the format, explains for you what goes into each. So an office memo, these are the sections in an office memo, a standard office memo. It has number 1, the heading or the caption. The heading is where you say to, like you're addressing it to a particular person, or C1. And then it has the question presented. In an office memo, usually there is a question which has been given to you by your pupil master, okay, or by the head of litigation or whoever you're writing it to. So usually the question presented could be, do you think our client has a defense, or are there any available options for our client, or what is the course of action, or what is the appropriate pleading that you could draft for our client? So usually in an office memo, you don't have issues. You have the question presented because it means you're being told by someone to research on a particular thematic area. So in an office memo, there is a question presented, and that is what you're going to subsequently advise on. And then brief answer. So you there's a brief answer to the question presented. Brief means yes or no, and it could be a maybe. Yeah. So sometimes you could have a yes or a no, and it could equally be it could be a maybe. So you will say maybes where you're uncertain, or there are 2 legal positions. So you could say maybe, that's your answer. And then fact, you go to the factual basis. Now you state what the facts are. And then discussion is what you will also call your analysis. And then you go to conclusion. So these are the parts of your office memorandum. Oh, I just remembered the name of my LWD lecturer. Her name was Christine Kungu. Yeah. So this is what Christine Kungu used when she was teaching, office memos. This is the format that your office memo takes. Okay. And then, so this is, let me show you one. Two, the name of the person you're sending it to. From, this is basically your name, the person who's sending the office memo, the date of the office memo. So this is the first part of your office memo, and it has a re. Okay, so there is either the name of the client, maybe they told you to research on the case of, let's say, Osiambu. So ideally, you'll write the name of the client. You might have a file which has a case number. So you could say Milimani miscellaneous application number 3 of 2023, Moses versus Vitu Mob or whatever. So the subject matter for your memo is, that's the way we couched it when we are doing legal opinions, but slightly different because it might be research on your client and, details, maybe the case number. And then consequently, you have to put a title of each of the section of your memo at the beginning of that section. Just ignore that, at the beginning of that section. So you start with question, you write like this: question presented. You remember how your legal opinion you wrote as your subheading, you have factual basis or factual context. So in this case, you write question presented, you proceed, and for example, if the question was, let me see whether I have a field office memo, but this one I did. Let me just show you this one. Let me show you this one. It has the answers. You will be able to understand if you see this one. So this is how this one looks like. Yeah. So office memo, to, from, and then the date, and then re. The re here is legal alternatives available to Dr. Rutherford. I think this is what you guys did for your exam. Yeah. What is it called? Farm work. And then question presented, you start like that, you write question presented. So question presented was whether Dr. Rutherford has any legal alternatives, nothing more, just write that. And then brief answer was yes, it is the duty of every employer to provide safe working condition to his employees, or hey, this is not gender neutral, yeah, to his or her employees, yeah, for you to be gender neutral. You can't just say his employees. And then consequently, statement of fact or factual basis. So this is where you're just telling the story. What more of importance is the format. Remember what comes first. Yeah. Don't start here with brief facts. Your format will be wrong. So of importance is remembering the format. So you start with the question presented, brief answer, and then your factual basis or statement of fact or background. So you tell your story on February 3rd, an employer at Eagles Water Company, while conducting routine maintenance, fell from a ladder and broke their hands. And the discussion is where, do you remember when you are analyzing our facts in the law, in the legal opinion? So in your office memo, that's how you're going to do it. Yeah. Like it's basically analysis where you're connection between the law, where you're showing the connection between the law and the fact. In this case, for example, the law clearly states an employee is entitled to provide a safe working conditions to their employees. Dr. Rutherford can be compensated. This is not good analysis. You start with just stating briefly what is relevant, the fact which is relevant. Well, this will suffice. In an exam, I don't think you'll have time to think about it, but just remember you have to have facts and then the law, and then you marry the two. If you remember articles of the Constitution, you could cite them. If you can remember a case law, you could cite it. If you don't remember, it's okay. But you have to remember some law. You can't analyze without the law. So you either remember some elements set down in a case, or you remember an article, or for you to analyze the law, you have to know the law, because it's impossible for you to analyze without the law. So, for example, here, Article 41(2)(b) stipulates that every worker has a right to reasonable working conditions. Yeah, so that will help you to subsequently discuss that. Not providing a proper ladder in good working condition Not giving your employee some protective gears is in dissonance with Article 41(2)(b), which stipulates that every employee or entitles every employee to reasonable working conditions. So you discuss this, basically analysis, just like we did for the legal opinion. And then after discussing, you have conclusion. Your memo has a conclusion. You just tell us, you answer the question. Yeah, this question which you are was presented to you. This question here, whether Dr. Rutherford has any legal alternative in your conclusion, it's supposed to reflect the answer. Having examined relevant laws, the water company owed a duty of care to Dr. Rutherford, which they breached and hence liable to compensate him for injuries suffered. This conclusion might not be very useful to the head of litigation. Yeah, so you might proceed and tell them what other options are available, besides compensating him. Is there anything else we can do? Can we maybe just try to negotiate with him, see whether we can improve his working conditions? Do we have to compensate them, or there are any other options available? So if there are any other options available, you state them in the conclusion. Don't just leave it hanging like that, because remember, someone will rely on this document to make a particular decision. So you have to be exhaustive. You have to tell them what other options are available to the company. Could we maybe try ask for forgiveness, or maybe try and talk to him, see whether subsequently we can improve his working conditions, give him protective gears, or maybe give him a medical insurance cover if he didn't have any. Besides compensating him, what else can be done? So that your conclusion has to capture that. So that is what goes into your office memo. Very quickly, everything is explained in this document that I was sharing with you. It doesn't have an actual memo, but it explains to you what the question presented is. Yeah, tells you what the question is, the brief answer, what goes into your brief answer. Your answer could be yes, it could be no, could be probably yes, it could be maybe, and then your factual basis. This is where you're stating the facts as given to you, and then discussion, this is where you're analyzing, and this is the heart of the memo. So you're basically here in the discussion, you are educating the reader about the applicable legal principles, illustrating how those principles apply to the facts. Yeah, so you say this is the law, these are the facts, and this is how they are related, or these are how they marry. Okay, and then consequently you have your conclusion. Your conclusion is the last part. So you summarize your analysis, and then in regards to the question presented, you tell them what can be done. Yeah, what options do we have? Because now you've already told us that we are actually supposed to compensate them. Can we do something else, or we have to compensate them? So you're going to read this particular document on office memo, see what goes into each part, and then you read an actual office memo, and then you proceed and draft an office memo, okay, for you to contextualize, because reading drafting questions is not enough. You have to go a step further and draft, okay? There is something I wanted us to do. I can't wait for us to draft bills. Bills, I'll ask you to come up with the title of the bill, which is, I remember coming up with titles of the bills is the hardest thing about a bill. Yeah. Okay. So one more thing, an affidavit. I want us to draft an affidavit, and I hope you're ticking from that. Don't tick now. You'll tick after you've drafted and you really understand how to draft it. Yeah. You might tick and then you lie to yourself. You can draft it. So you draft first and then you can take it. You can actually get a blank book, even a 120-page, that's even a lot, like 90-page notebook, and then you draft each of these documents. All of them, you have to draft each one of them for you to remember the format or what goes into each of the document, because all of them have formats. All of these documents have formats. Let me project an affidavit. We could use an affidavit of marriage. Let me get an affidavit. So usually an affidavit is used for purposes of, there are really good notes here from that class that I was telling you for affidavits. I'll share that with you, but in the meantime, I'm going to project an affidavit. So an affidavit usually is a document which is used. The person who does an affidavit is called a deponent, and it is used for stating facts, yeah, putting facts in writing. So we have an affidavit. Let me share some notes here on affidavit, and then we look at an affidavit. So an affidavit could be, an affidavit is sworn under the Oath and Statutory Declarations Act, and it has to be sworn by an adult of sound mind and someone who's, it can be done by a minor. And then the functions include, it serves as evidence in a court of law, confirms names or marriage, or for purposes of insurance. It can be done on behalf of a company. Types of affidavits, there are so many types of affidavits. But for your purposes, in LWD, no one is going to ask you to draft a verifying affidavit. A verifying affidavit is an affidavit that accompanies a plaint, accompanies a statement of claim, and also accompanies a divorce petition, which basically is meant to, authenticate the fact that are in those pleadings. So verifying affidavit is civil litigation, and then supporting affidavit accompanies applications. And then a replying affidavit is used to respond to applications. You won't draft these here in LWD, but there are types of affidavits nonetheless, okay? And then a further affidavit is used, for example, after you've done a supporting affidavit or you've done a replying affidavit, and there's something you've forgotten, yeah? You've done your documents, but you feel like I need to say something more. There is a particular paragraph you feel like it's not exhaustive, you want to add to whatever affidavit you filed. You can file a further affidavit, which is different from a supplementary affidavit. A supplementary affidavit is used to respond to a reply. Let me write it. A supplementary affidavit is used to responds to a replying affidavit. Okay, and then a further affidavit is made to add to the facts, either in supporting affidavit, replying affidavit, or replying affidavit. Yeah. So those are the types of affidavits, but majorly these are local civil litigation affidavits. For our purposes, we might need affidavit of marriage, mostly affidavit of marriage and affidavit of names. Those affidavit of marriage, names, those are important affidavits for purposes of LWD. Okay, so I'm going to project. Let's start with marriage, an affidavit of marriage, and then we look at one for names. There are some notes, like 50 slides on affidavits. I'll share those with you. You look at them. In the meantime, let me check an affidavit of marriage. Ooh. So affidavit of marriage is meant to show that you're married, or okay, let me share. I was deleting those details for the client. So an affidavit of marriage looks like this. So you'll have the caption here, Republic of Kenya. Guys, we're drafting an affidavit of marriage in October 2022. So affidavit of marriage, and then you state your name. You could do this, both of you. You could be doing this, both of you. You can be two deponents, the parties to the marriage. Okay. So you could be we, A, and B, both of Kia, Nairobi, and holders of ID number, respectively, do hereby make all then state as follows. So an affidavit is usually made under oath. And the reason why you're making an affidavit under oath is because, I think I've told you this before, Cindy, it's because if you lie under oath, you'll be liable for perjury, which is a punishable offense under the penal code. That's why you're making an affidavit under oath. And then you proceed and tell the story that you're both adults of sound mind. So this paragraph is meant to state who you are. So it shows that you guys are both adults. Remember, persons who can make affidavits have to be guys who are adults and you have sound mind, hence competent to swear this affidavit. And then you say, you give those facts leading to your marriage. That sometime in August 2016, we lawfully contracted a marriage under African customary law, to which both of us are subject to. Don't say these, use simpler terms. Don't say subject to. It sounds extremely, I don't like how it sounds, yeah, but just shows that both of you are actually subject to that particular customary law, and you are both unmarried and single then, yeah. So this could go into another paragraph that you could say that at the time of contracting the marriage, we were both single. That sounds simpler. Sindio. So you have to use those simple sentences like you're addressing class 3 toddler. That at the time, I won't type it, but I'm saying that at the time of contracting that marriage, you are both unmarried. And then the next paragraph, that all the rights pertaining to the African customary law have been performed and dowry fully paid. That we swear this affidavit to confirm that you are lawfully married for all intents and purposes and currently live together as husband and wife. That since the said marriage, we have been blessed with 5 children. That I swear this affidavit conscientiously believing the content. This has to be there. This paragraph, you just put it as it is here. Any if you write it, you'll remember it. You'll just remember. This last paragraph usually is there. I think I've told you that it's called in another forum during civil. I told you this paragraph is called averat. Yeah, I've told you that before. It's called averat. So this paragraph is meant to, you're just saying whatever I have said in this affidavit is very true to the best of my knowledge, information, and belief, and in accordance with the Oath and Statutory Declarations Act, Cap 15, Laws of Kenya. And then this is called a verat, this entire paragraph here. It's called verat. I mean, this entire, whatever this is, those are called verats, Lord. Those are called verats. So you write the name of the deponent. The deponent could be both the wife and the husband. You write their names there, and then they're called, they're not called declarants. They should be called deponents. Declarants are for statutory declaration. So these are called deponents. Deponents. So they write their names there, they sign for you there, and then consequently you have a date here. There should be something else here. Those ninis, you know them. I don't even know what they're called. Yeah, they should be there as well. But you have to have this, the verat and the jurat, and then drawn by, not drawn and filed by, unless you're going to file this affidavit in court, but it's basically just drawn by, you write the name. There's a question, it's October 2020, 2022, last year. It was an affidavit. Let me get you the exact question. Let's look at it together. Let's look for it together because it's already 10:17. Let's go to that paper. We scroll, we get it. But you have to draft. Sindio, you really have. By the way, you know this unit, you don't even need theory. If you can draft, you know all those documents that you've written. If you can draft perfectly, it's a clean 40 out of 60. Just like that, without any theory. Yeah. Because mostly you'll draft a lot in this unit LWD. Just a minute. Let's go to the questions. So October 2022. I'm not sure whether you can see, so let me share again. Okay, yeah. You know, weirdly, I but you guys might not trust me. You know, at some point I even miss coming back to KSL. And then I wish, you know, I didn't know this much when I was at KSL. Now things are much clearer after you start doing these things practically. Okay, ATP 103 here. The first question was power of attorney. That's why I'm telling you, you guys won't draft a power of attorney because it was done in the second last paper. Guys were drafting a power of attorney here. But don't, not a prescribed form. And then there was a question here. Draft the relevant legal instrument required by Francis to obtain a medical insurance cover by his family. So you would have done an affidavit of, there is a affidavit. I have not read this entire question, but I'm not sure he's taking the cover for who. Yeah, there is a customary marriage here. So read this. There is a customary marriage. The couple has some children. Yeah, should be an affidavit of marriage. So attempt drafting this. You're even given the ID number. So actually, this shows you it's an affidavit, and Angela's ID number as well. There is another one, but in a different paper. I'll get it for you. Okay, but if you scroll these papers, you'll see they have a lot of drafting. If you just look at this one, just this one for last year, the last question is give a title to a contract. Number one. Number two, draft the appropriate clauses. That's a drafting question. And then the other question is draft a legislative instruction. And then the other question is that proceed and execute that legislative proposal. This is a legislative proposal. This paper has a lot of legislative drafting. And then the other question asks you to draft the legal instrument. Those are three questions so far. And then question one asks you to draft a power of attorney. Yeah. So what you do is you draft because 4 out of 6 questions you're drafting something. So you have to, by the way, draft, just keep on drafting every single document. Draft with your pen and a paper. Don't type with a laptop. Hey, you might lie to yourself, and then shortly after you're supposed to draft and you are drafting with a laptop. Nakwambia, your fingers will become sore first of all, and then the seat will become uncomfortable all of a sudden, and you want to go home. You are like, you're done. It's never that serious if you don't draft using a pen and a paper. Okay, so don't. So what you do, get a book if you don't have a plain book for specifically drafting legal LWD document. The list I've given you, start with the first one, demand letter. Write an entire demand letter with a pen. Number B, write a reply to a demand letter. Number C, write a legal opinion in form of a letter. Draft an office memo using exam questions. You can use exam questions. And then you go to an affidavit, draft an affidavit, draft an SD, or do statutory declarations, draft a case brief, draft all of those documents using a pen. I'm telling you, by the time you guys are doing that paper, you'll be so, you won't struggle. People are struggling huko kuandika, unashanga 3 hours ni za nini, ushamaliza. Okay, so keep on drafting, don't slack. Okay. So let me stop sharing. It's 10:22. Let me know whether you have questions. I want to give you some other questions, which will make sure you have drafted. There is November 2019. November 2019, question 5. Draft that one. Draft. Okay. And then can we draft a bill in the next class? I would like us to draft a bill because bill was not tested in this paper. It was equally not tested in November, so bill might be in yours, okay? And amendment of bills. I actually thought the March guys will do amendment bill, but they never did, especially because of you remember the unconstitutional constitutional amendment. Because of that constitutional amendment bill, I thought they would do an amendment bill, but they never did. So you guys might do amendment bill and a legal opinion. So let's do that in the next class. Cynthia, we are going to draft bills in the next class. So our concern over here is just drafting, and then I'll leave you guys to look at the theoretical bit because theory is easy. Yeah, it's basically very easy. It's in black and white. You need not, you don't even have to struggle for theoretical bit in WD. It's very straightforward. Okay, so let me stop projecting now. We don't have a question. I can't see any hands up. Thank you so much, guys, for the indulgence. It's usually very humbling to have you all here. I really, really do appreciate all of us. And we said when it gets too tough, you just buckle up, you're almost there. This other side, it's very rewarding. It's extremely rewarding. I promise you, it's very, very, very rewarding. And this is my small way of giving back. You have to give back. You have to send the elevator back down. That's what I'm trying to do. I'm not even, I've been doing this for quite some time, and it's very fulfilling on my part. It gives me purpose. Yeah. So I'm always here for you guys. I am always in your corner. I'm all about you. So just reach out anytime you have a question or concern. I'm here. And if you want to break down, I can give you a shoulder to cry on. Yeah. So I am here. Have a very good night. Thank you so much for the indulgence. DM me your email addresses for the recording. Keep on drafting and keep up. Your stars are aligning. Have a very good night and goodbye.